with Hooper Law Office, and today we're going to be talking about kind of a big overview of estate planning and how you can use that to protect your legacy or protect your wishes. So legacy means a lot of different things for different people. That can mean maybe making sure that your assets go where you want them to, or that your family follows certain rules and stays together, and you avoid fighting, right, or conflict in the family. So it can mean a lot of different things. But from a very basic overview, a lot of that can be dealt with through how you coordinate your assets with your estate plan. So we'll kind of go through how that process works, both from a will standpoint, from a trust standpoint, just so you have a general overview of that. But before I dive into the information, as always, this is interactive. So if you have any questions, you can submit them to the Q&A function if you're participating via Zoom. And I'll see those come up. So please feel free to do that as I'm talking. It'll allow me to kind of answer questions once I get through everything. And then keep an eye out for a couple of things coming from us to the email that you use to sign up. There will be a document finder, a tool that we've created that helps you list where you have certain documents being kept, if it's in the safe deposit box, if it's at in the safe at home, where are you keeping your important estate planning documents? So you'll get that tool from us, complimentary. And then part of that email too will also have a feedback form where you can use that feedback form to, of course, give feedback, but you can also use that to let us know that you'd like us to reach out to set up an initial consultation with our office. Those initial consultations are complimentary. We do schedule them for about 2 hours. Give us plenty of time to go through your situation and answer any questions you might have. But again, those are complimentary. So that's not something that you, when you sign up, it's free to come in and talk to us. We can give you a good idea of the overall cost generally by the end of that meeting of whatever it is we're recommending. Okay, so to get started, when we're talking about protecting your legacy, I mentioned that one of the biggest things that people need to be aware of here is making sure that if they have planning in place, that they're coordinating their assets with that planning. And I'll go into a little more information on what that actually means and entails, because it's not often as simple or as straightforward as people think that it is. But first and foremost, if you don't have planning, this maybe goes without saying, but if you don't have planning in place, you really should get that planning in place. You should have documents that explain what your wishes are, who you want in charge of certain decisions, whether that's financial powers of attorney or healthcare powers of attorney during your lifetime, or if it's naming somebody as the personal representative of the estate through your will, or naming them as a trustee of your trust. Making sure you have those important people in place and that you've set aside time to designate those individuals. What you don't want to do is leave people in a position of guessing how to make certain decisions or who's supposed to be making certain decisions. So when we have documents that you're going through and creating, this is where you would name these individuals. So powers of attorney, although this seems like this wouldn't really protect your legacy, it's important to have these documents in place so that if you lose capacity, if you can't make decisions yourself, that you actually have somebody you've named and trust to act in these roles. If you lose capacity and you don't have a power of attorney signed, or if the power of attorney you have is maybe doesn't have the authorities that that person would need, you can ultimately end up in a process called guardianship. And I won't go into a lot of detail on guardianship today, but know that it is a court process in which family members or individuals can petition the court for guardianship over an individual, kind of like you would a minor child. But this can also be with adults who have memory care concerns, cognitive decline, right? Or maybe adult children who have special needs where they need that continuing relationship. So it's a process in which you are actually selecting rights over an individual and having those transferred. Well, this process can be avoided almost entirely especially when it comes to somebody who is just having memory care concerns, if they would have had robust powers of attorney in place where they have all the authorities they need, they have the people they want making these decisions. If they've signed these documents before they get to that point of decline, they can avoid that process of guardianship for the most part. There are still some circumstances where if a person is causing harm to themselves or is refusing to potentially like go to a long-term care facility, but that's where they would need care, where there's circumstances like that where guardianship could still be necessary even with the power of attorney. But what you don't want to have happen is somebody end up in that process simply because they didn't sign a power of attorney that allows things as simple as going to the bank, paying bills, writing checks, right? But it's not just as simple as those authorities. There are also some more in-depth authorities you'd want to see for things like long-term care concerns if you're trying to protect assets. So it's not a one-size-fits-all document, but you want to make sure that you have these in place while you still have the capacity to sign, because you could have the best will or the best trust in the world, but if during your lifetime you don't have those people who have the authority to step in and make certain financial or healthcare decisions for you, you may not have those assets left to protect if you were not able to do any additional planning like after a decline in capacity. So powers of attorney don't seem like they would have anything to do with protecting your legacy, but they definitely can play a role depending on what happens with your health down the road. But getting more into the meat of the topic today, when we're talking about like planning for somebody's legacy, like I said, that can take a couple different, like people can view that differently depending on how they view their legacy. Is that legacy a financial one? Is it a charitable one? Is it, about keeping the family together and having maybe a legacy property that they're trying to keep in the family? Whatever your idea of what your legacy is that you'd like to leave, it's very important to make sure that you have either a will or a trust in place to capture that legacy. So when we're talking about, for example, somebody having a will in place, most people are at least aware of what a will is to some extent, but they may not have a good understanding of how these actually work. So we all are aware that wills are where we put our wishes down and name the executor or personal representative, where we put these people in charge to make decisions after we're gone about the estate. But most people don't understand that when you have a will, that will is only going to direct assets that are actually subject to the probate process. So if you have a will, you're not avoiding the probate process. You're actually saying that this will is only valid in probate. That's where it has to be administered. So that can actually create a lot of problems when we talk about planning for someone's legacy. So you can put certain wishes in your will of how you want assets divided, or if, excuse me, there's family property that you want to have certain rules put in place for that family property, you can put provisions like that in a will. You can do charitable planning through a will. But if you don't have your assets that you own at the time of your death subject to that probate process, and it, maybe you're payable on death, transfer on death designations differ significantly from what your will says, your will is not going to be administered properly. You won't have the things you've listed in your will actually apply to the assets that you own. So this is one of the biggest issues we run into when we see people who come in with wills. They may have really good planning in their wills about how they want their family cabin dealt with, how they want the assets divided, how they want their charitable wishes met, right? But when we look at their bank accounts, their retirement accounts, their life insurance policies, those types of assets, oftentimes they have payable on death or transfer on death designations that either somewhat match the intent of what they have in the will or maybe don't at all. And the problem with that then is whatever's in the will is not going to apply to those assets, because payable on death or transfer on death designations, or if there's an account that's jointly owned with somebody, those are not subject to probate upon your death. They go outside of that process. So if you have planning in your will and you want it followed, you have to use the probate process for certain assets. You can't, you can try to honor somebody's wishes as a recipient of those funds, but there's no guarantee that those wishes will be met if you don't have assets subject to the probate process along with the will. Now, this can create other issues in addition to just not having things go where you want them to. One of the biggest issues we run into when we have a will and assets that are not subject to probate when someone passes away would be in regards to bill paying. So when you have someone nominated as that personal representative, In theory, that's the person who is supposed to be responsible for the bill paying of the estate, making sure they inventory everything, give notice out to the creditors, if there are potential creditors, give notice to the beneficiaries of what they're entitled to receive, right? That's the person who is the manager of that estate. However, if on your beneficiary designations, let's say you just named all of your beneficiaries, that person who is the personal representative won't have direct access to those funds as the personal representative to actually pay expenses, to have that go through that probate process and make sure that they're following all the proper steps. Even if they are one of the beneficiaries on those accounts, if the personal representative is also somebody who would be inheriting, now you potentially are asking them, the funds they've received, are they supposed to use their inheritance to pay the bills? And there's no guarantee if they do that, that the other beneficiaries will have to reimburse them, because on a payable on death transaction, those recipients, it's their money now. It doesn't have to follow the wishes that are in the will. It doesn't have to be subject to that probate process. So if you have beneficiaries that are listed as a payable on death or transfer on death beneficiary, but you also want somebody to be able to pay bills and make sure that your end result, that everybody shared in those expenses equally or proportionately, then you need those assets potentially subject to the probate process. Now, even when you have a will, you may not have everything subject to that probate process, but you want to make sure that there's at least enough there that your wishes will be met, that expenses can be paid proportionately, that personal representative has access to those things. Now, on the reverse side of that, we sometimes see people name the person who is going to be the personal representative as a sole beneficiary on an account, and then they expect that person to share those funds with the other individuals. The issue here is, again, just like with the prior example, if somebody's a recipient of funds through a payable on death designation, beneficiary designation in general, or they're a co-owner on an account, after your death, that becomes their money. And it's not subject to the probate process, so they don't have to use it to pay your bills. They don't have to honor your wishes that are in the will. Now, you'd certainly hope that most people would, but it's important to know that they don't have to, because there can be, in addition to them not wanting to do that, split at your death, not sharing those assets, there could be legal reasons that they can't do that. We often have situations, for example, where there might be somebody inheriting who is on Medicaid when they're inheriting those assets, or is in a nursing home. Maybe they're in a bankruptcy or about to be in a bankruptcy. Those are circumstances in which that person is not allowed to transfer assets that they've received. They have to be put towards those liabilities. So if there's concerns about that person needing those types of services or needing to go through a bankruptcy, you can run into a situation where you have somebody who, even if they want to follow your intent, is unable to do so. If you have your assets go through the probate process with the will, that personal representative will have access to those funds and they will be able to pay expenses. And then they have to share it according to your wishes. So it's really good planning to make sure if you have the will and that's where you have your wishes, that you have that followed. You have those assets directed through your probate estate. And you can do that a number of ways. You can either have a bank account, for example, if we're talking about your checking account. You can have that set up where there's no beneficiary at all on it, or you can have it go to your estate, and that would send it through probate. So if you have planning in your will, you need assets to be subject to probate if you want those assets to follow the terms of the will. This is in particular important if you have legacy property that you're trying to plan for as well. So you want to make sure that bill paying is dealt with so that the family stays together, that there's no conflict about, well, how are they using funds, right? I mean, that can be a huge issue where there's bill paying that there's question of whether it was done properly or those assets were shared accordingly. So beneficiary designations are certainly tools that you can use to effectuate your legacy planning. There can be times where you name a charity directly on a beneficiary designation, and this can make sense for things like pre-tax retirement accounts, where those charities are not going to pay taxes at all on the receipt of those funds. So if that's the case, we sometimes will name charities directly as a beneficiary on an account, but then we use the other assets to make sure that if it's a will that person is using to pass their assets, that at least that person who's named as the personal representative has access to some level of funds through the probate process to pay bills. So with kind of the alternative to using probate. If you don't want to use that process, but you still want your wishes followed, this is often where we look at things like trusts to do this planning. So a trust, as the alternative to a will, it functions a lot like a will in that you put somebody in charge of it after you pass away. It directs the trustee to follow your wishes and split the assets after expenses are paid, right? So in a lot of ways, it functions like a probate in that sense. However, there's no court involvement, there's no probate. So it is generally a faster process than probate to administer a trust. It depends on the situation, but that's generally the case. But trusts end up being a bit of a combination of like a payable on death designation, transfer on death designation, and a will. They have terms that have to be followed in it, but allow them to be followed while still avoiding probate. So when would you use either of these tools to pass your assets? When you're looking at using a will, we often get questions of, well, why would I want to go through probate? I've heard it's awful. Why would I want to do that? And the reason people often want to avoid the probate process is because it can take a long time. On average, you'll see a year to a year and a half as a pretty standard time frame for a probate. Sometimes it takes longer depending on if there's fighting going on or challenges to an appointment as a personal representative. There can be reasons that this process takes longer. But generally speaking, a year to a year and a half is pretty standard. Another big reason that you see a lot of people, trying to avoid probate at the very least is the costs associated with it. Now, the cost ranges depending on how the attorney charges, if an attorney is hired even, how complex the situation is, what the filing fees might be, the potentially like the types of assets that are going through. So it can range, but you see standard figures quoted in the area of 3 to 5% of the value of the probate estate. So it can be pretty expensive to go through probate, especially if you have a more complex, larger estate. So the cost associated with probate is a reason that a lot of people would try to avoid that. So if you're using a will as your basis for your planning, the problem you're going to run into there is if you want to avoid probate, that's just not the right tool. So that's where people looking at trusts might say, well, what does that cost on that end? And when you're using a trust to pass your estate outside of the probate process, again, this can range depending on attorney's fees and all of that and the complexity of the situation, but you'll generally see sometimes, in the range of 1% of the estate or under 1% of the estate after all is said and done. So it is generally less time intensive and less expensive to avoid the probate process by using a trust for the estate. Another potentially common concern that people have, this depends more on the person, I suppose, but probate is a court process. So it is potentially public. And by that, I just mean you can go look up the records of somebody's probate estate. I mean, just like you can when you CCAP somebody who might have been convicted of a crime, right? It's a court process, so you can look these things up. That could potentially be a concern if you're a very private person. It could also be a concern if you have young adult children, so not minors, but younger adults that you're trying to protect from somebody, knowing that they're inheriting a potentially large sum of money. Trust administration is private. There is no court involvement. So there is no knowledge that people have of what the trust says other than the beneficiaries and the trustee. There's no information out there of what assets are owned by the trust. There's no way to look up this trust. So it's much more private as a process than using a will. Both wills and trusts are very good tools to use to plan for your legacy, to put provisions in there regarding where you want things to go, how you want certain property dealt with, or who you want in charge of these, bill paying type situations after you pass. But you have to know that if you're using a will to pass assets, that will only be valid in the probate process. So if that's what you're using, you should coordinate some of your assets to go through that process. If you're using a trust to pass your assets, similar to a will, you still need to coordinate the assets, but you do that by either naming the trust as a beneficiary or having the trust own those assets during your lifetime. So you still need to coordinate everything, but you can do that with a trust while still avoiding probate at the very least. So which of those is right for you is just going to depend on the situation. When you would want to use probate, for example, is if you have minor children. That's where guardians are named, right? They have to be nominated in the will. If you have a deficit estate, so if you owe more money than you have, using probate for that process can be helpful because one, you have to give notice to the creditors through that. So they're going to have the ability to come forward and take what they may be owed. It may mean that the beneficiaries don't get anything, but that also means that the personal representative doesn't bear any responsibility for that, for not giving that proper notice. They've done that through the court process. So if you have a deficit estate, you have minor kids, that can be a really common reason to go through probate. I've sort of alluded to the third reason, and that's if you have particular planning that you want followed in your will. If you're doing that through a will, you need to use the probate process for that planning to work. So if I have a trust set up for a minor child through a will, if I have like a family cabin trust that's created for that in the will, well, then you need probate to actually happen in order for that will to establish that trust for those individuals or for that purpose. But if you don't have those concerns and you still want to avoid the probate process and you still have that planning in place, that might lean somebody more towards a trust than using a will. When we're talking about protecting your legacy in regards to property, this can be a very common concern for people who have hunting land, or for people who own businesses or farm property, hunting land or cabins, I mentioned as well. So whatever type of property it is, if it's important to establish rules around the use of that property or structure around like succession of ownership down the road, you need to make sure that you're doing that planning in your will or in your trust to actually establish some sort of structure there. And oftentimes this can also involve some form of a business entity to own these properties as well. It's not a one-size-fits-all situation. It depends on how you're using the property, who's going to own it, what level of restrictions you're putting in place on ownership, right? But the worst thing you can do if you're trying to protect legacy property is nothing at all. A lot of times people will say, well, okay, I'm going to have it split up amongst my 5 kids. They're going to figure it out, right? They don't fight now, they'll get along. Well, it's not often even at that first generation where issues come up, right? It can, siblings can fight just like anybody else. And I suppose the more siblings somebody has, the more likely that is to happen. But it isn't often on that first death where people really run into issues. They can often get through it. A lot of times the siblings are close enough that they'll agree on, well, okay, this is how we use it. This is how we pay expenses, that kind of thing. But it's sometimes the next generation down or the one after that where it's very difficult to make sure that if there's no other structure in place, that this property really stays in the family, that people don't get sick of one another and try to get out of ownership. And, or potentially that the property just ends up being sold because nobody wants to deal with it at that point or deal with the other people. So if you have property like this, there's a couple things that you really need to think about, regardless of which type of tool you're using to pass this property. You need to think about, do you want to restrict the number of owners even, or do you want to restrict who can be an owner? Does it have to be a descendant of yours, or can it be a spouse? I suppose there could be reasons that you would allow spouses in as well as your own descendants, but that's a personal choice. And think not just down the first generation, but the one after that, and say, well, what about when our kids pass away? How is that process going to work? So you need to think about who the owners are or who you want to be an owner, and potentially how many people at most you want to be an owner, because that is where the next generation down, not the first step down, but the one after that, where things can get really difficult. You also need to decide if it is a family like property that a lot of different people are going to use, how is that used? Are there structures in place around scheduling usage? Who pays the bills for these properties? What happens if somebody doesn't end up paying their fair share of the bills, right? Do they start to lose ownership? Or do they get kicked out of the business or the structure that you have in place so that they don't have, maybe they're not paying bills anymore, but they're also not getting to use the property? I'm listing off a bunch of different things that you need to think about or could think about. You don't necessarily have to put like the most restrictive rules in place, but you do need to understand of what your intent is behind these properties, how you want them used, And if you have certain wishes for how they're supposed to be used or what happens if there's disputes, you need to put that in writing and put that in place before you pass away so that you can guarantee that those are going to be rules that at least that first step down has to follow, the first generation does. Your family can always agree to change certain rules depending on how you pass this property down. But then, it's much easier for you to decide these rules, or you and your spouse to decide these rules, than it is to get 5 or 6 different people together to decide on a set of rules, right? So if you have legacy property, it's very important that you consider how to pass it down, what rules you might want in place, what happens if somebody doesn't want to be a part of it anymore. Do they receive any value or not? If somebody doesn't want to be a part of it, are they getting assets to replace what that value would have been for them? These are all things you need to consider for legacy property. So protecting your legacy through your estate plan can, of course, apply to the more basic, well, just where do you want things to go? What process do you want to use? How do you make sure bill paying happens, according to your wishes? That's all perfectly, reasonable things to consider when you're creating an estate plan. But it's also worth looking at, if it is a certain type of asset, are there other things that you also want to plan around, the future use and ownership of this property? The last thing I haven't touched a whole lot on is the charitable side of things. And if you have charitable intent, how do you want that charitable intent met? If your wish is I just want to leave a sum of money to these organizations, and that's, I can do that just fine through payable on death through my IRA, well, maybe that works for you. But you also want to look at, is it worth considering, do you want to establish a more long-term charitable plan, something that continues past your death, something that might continue on for years? And if you want that, how do you structure that? There are organizations out there that you can leave your assets to, or leave what you want to leave to charity to these organizations that try to continue on your giving pattern long after you've passed away. So there's ways that you can stretch that giving out a lot longer too, if that's your wish. So when it comes to charitable giving, you want to make sure that you're doing it in a way that if you want it to be passed down for a longer stretch, that you have that structure in place as well, or that you leave things to an organization that can provide that structure to you or to your assets. Some people also, when it comes to charitable giving, would like to have their children involved. They want to pass that charitable desire down to the next generation. And so they might set up some sort of structure for the kids to decide where those funds go, but that it's up to the kids. It has to be used for charity, but maybe they get to decide where it goes, so that you can establish or instill in them that desire to leave things to charity too. So none of this is to say you have to leave things to charity or that you should be leaving things to charity. It can be great if that is your wish. But if you have certain wishes around charitable giving, around your family legacy property, it's important to make sure that those are very clear and that you're not just leaving it up to the next generation to figure it out. Because that's, you may have a legacy you want to leave, and that's not really good legacy planning. You're just hoping that they know what you intended. So I'm getting towards the end, and I do see a question here. So if you have an asset protection income trust, and the trust has a revocable trust because they're the owner. If they're the owner and it's still the owner's asset, would be required to use the assets for nursing home care prior to the state stepping in to pay Medicaid. So if you have a revocable trust, are the funds potentially available for nursing home care, is how I'm understanding that, at least. So if you have a revocable trust, and one of the spouses goes into care, or if it's a single person who goes into care, the assets of that trust are potentially available assets for care for revocable trusts. So Medicaid law in Wisconsin says if it's a revocable trust, it is an available asset, or essentially it's subject to the same rules that you would have as if you didn't have a trust. If your trust was established prior to 2014, it's still an available asset for care, but that just means that Medicaid can't come back against the older revocable trusts for recovery purposes after that person passes. So when you're looking to protect things from nursing home expenses, if that's part of your legacy planning, you often want to look at using some kind of irrevocable trust to do that, because irrevocable trusts are not available for Medicaid. They don't count as an available asset. That doesn't mean you put everything into that irrevocable trust. You want to look at which assets are important for you to protect. So actually, perfectly tying into the legacy property discussion, if there's a family cabin that you don't want to have to sell if you go into a nursing home, and it's important to keep that in the family, or if it's a farm that's important to keep in the family, we oftentimes look at creating irrevocable trusts to hold those assets as somebody gets closer to needing care. So to answer the question, hopefully, if you have a revocable trust, it is an available asset potentially. It's just subject to the same rules as if you didn't have one. So like the primary residence, if one spouse is healthy, might be temporarily okay until both spouses need care. Like the retirement accounts of the healthy spouse are not available for the other spouse's care, but it's not protected forever. So if you're looking to protect assets from Medicaid availability so that they don't have to be spent down on nursing home expenses, then an irrevocable trust is what you'd be looking at instead. So I hope that answers that question. Is there a minimum or maximum that we can access, or do we have to terminate access to the funds? So great question. When you have an irrevocable trust, if you're trying to protect things from Medicaid, you generally want to pick and choose what it is that you're trying to protect versus what it is you want direct control over yourself. Now, if we put real estate into an irrevocable trust, we're always granting the right for that original owner to still use the property. They can't be evicted, charged rent, have it sold without their permission, as long as they continue to pay property taxes or utility bill, the expenses of the property. So real estate, you maintain a lot of usage control over. But when it comes to funds or like selling that property, if you want to maintain direct control over funds that you're putting in, or you want to maintain control over like decisions to sell or buy property, using an irrevocable trust is going to limit your options there. If you have those levels of control over assets within an irrevocable trust, there's always the risk that it could be considered eventually available for Medicaid, because if you have the ability to direct it, it's potentially available. So when you're looking at nursing home protection planning, if you're looking to protect things from spend down for Medicaid, you want to be very careful and understand that if we're putting these assets into the trust, that these are assets we don't intend to necessarily have direct access to ourselves, that we transition to the trust, that the trustee has access to, but that we don't have direct access to anymore. So the asset protection trust, is that a revocable trust or irrevocable trust, or can you pick and choose? So when we're talking about asset protection trusts, that's a pretty overall term, but those are generally irrevocable trusts, because if they're revocable, they're not going to have that level of asset protection. So if you're looking at an asset protection trust, you're looking at an irrevocable trust, not a revocable trust. So hopefully that answers that question okay. And then, so I'm a little over time. So if anybody has any additional questions, please feel free to submit them right now. If not, you can always email us at learnmore@hooperlawoffice.com, and we'll be able to get those questions answered for you too. As a reminder, please feel free to fill out that feedback form where you can let us know if you'd like to set up an initial consultation to come in and talk with one of us. Again, those are complimentary. And then if you are interested in hearing about all these things in more detail, in a more kind of broader overview of things, please sign up for our in-person wills versus trusts public seminar. It'll be next week on Wednesday. There will be a 2 p.m. and a 6 p.m. It'll be at the Neville Public Museum in Green Bay, and you can sign up for that on estateplanninglive.com. I hope everybody has a good rest of their day, and hopefully we'll see you guys